Welcome, everybody, to today's Lunch and Learn session. I'm Jennifer Shirk. I'm the director of the Association for Advancing Participatory Sciences. And I'm really pleased to introduce today's session on the timely question of whether states can ban the use of community monitoring data. We're hosting the event today in collaboration with PurpleAir and with support from the Clean Conferencing Institute, which is a new organization that's supporting and increasing engagement in virtual events. From that group, if you have a chance to talk with Sue Allen or Josh Gutwell today, please say hello and thank you to them. Next slide, Rihanna, please. Today's event is the first in a series of Lunch and Learns, and it's just one of our many programs. AAPS, our association, was formed over 10 years ago by and for people who are working to bring research and communities, and that's local or global, together through science. And while this association was first called the Citizen Science Association, the movement itself was quickly recognized as much broader. So members are really the driving force of this community, of the association, and AAPS as an association provides structure to bring people together around the practices, provide a space to curate expertise through our conferences and our journal, and to be a home for networking and invigorating conversations that advance this movement and the practices to increase the rigor and the trust in science and build our shared understandings through these practices together. Next slide. So we're really pleased today to have a much bigger audience than we anticipated for this Lunch and Learn session. To facilitate engagement, our sequence of things is going to be to provide a little bit of context, to offer time for structured Q&A, as well as some reflections, and then we'll go deeper into conversation in breakout rooms. For the best experience, right at this moment, we're keeping the mics off just for now, but you do have a lot of control over what you see, including tabs at the top of your screen that will allow you to toggle your view, and you can see a screenshot there. In that screenshot, you also see Rhianna Putnam. She's the program manager for the association, and you'll be hearing more from her. She'll be facilitating the Q&A and much of the rest of this session. Before I officially introduce the event and the speakers, I will say that this is a conversation that is informational, and it's not something that can constitute official legal or policy advice, just to get that on the record. So with that, next slide, we're going to turn to today's guests. And I'm really pleased to have these experts leading not just this session, but also this whole effort that we're talking about today. Benforado and George Wyeth were the authors of the amicus brief that you'll be hearing about. We're also joined by CEO of PurpleAir, Adrian Dybwad, who will share his reflections as someone who's actively involved in supporting many communities in this work. And I'm going to let each of them introduce themselves at the appropriate moment, but for now, we'll turn it over to Jay to get us started with the content. Jay, over to you.
Thanks, Jennifer, and welcome all. I put some slides together to be efficient. You can read faster than I can talk. If we could cue up the first slide. I wanted to start with an overview of the air pollution issue in Louisiana. There are a large number of fossil fuel, petrochemical, refinery operations. You've probably heard of Cancer Alley, that long corridor between Baton Rouge and New Orleans, where there are particularly high levels of toxic air pollution. I've listed some of the kinds of pollutants: particulate matter, ozone, volatile organic chemicals, and then there's some specialty chemicals as well. And the reason we're here is because air pollution results in health impacts and also environmental justice concerns. The heaviest pollution burdens are often located in Louisiana in majority Black communities. And the link to community air monitoring is that we have insufficient monitoring. Next slide, please. This is where community air monitoring comes in. I wanted to just give you a quick guide. At the bottom right, you can see a link. There's some excellent training that EPA put out in last year if you want the basics of community air monitoring. But it's a team sport. It brings together community groups, scientists, government agencies, federal, state, local NGOs. Huge advances over the last couple of decades. Great work by community organizations. We'll hear a little bit today from Adrian on some of the new technologies. Some funding, EPA and states have given some grants, and then assistance from the science community. And it supplements regulatory monitors, provides additional useful information. And the end result is that we have more better information to help solve air issues. Next slide, please. And I am going to go quickly so that we save time for discussion. I list some of the values of community data. You can see it provides screening level data where you can come in and do more advanced monitoring, can identify hotspots, areas where additional monitoring enforcement might be needed, can provide early warning of potential accidents or pollution spikes, can also be used to locate where the pollution is coming from, traffic, industry, etc. It's invaluable for health researchers for more accurate assessment of health risks, and then also can inform policy and decision making. Next slide. And unlike Louisiana, many states have tried to figure out how they can support community air monitoring, and I give some promising examples here. California has been a leader. But also one of my favorites is Minnesota, where they're now setting up some neighborhood. They've worked with communities to set up neighborhood scale monitors in the Twin City area, and you can see some of the what some of the other states are doing here. Next slide, please. So now into the topic at hand, the Louisiana law titled the Community Air Monitoring Reliability Act was enacted in 2004. The law limits how community groups can use data from their own low-cost air pollution sensors. It makes it illegal to use this data to, quote, allege violations of environmental law. And basically, it bans community air monitoring. And this approach is concerning in Louisiana for community air monitoring, but also for the whole field of participatory sciences. Next
Jay,
slide, please.
Jay, I will just correct a typo. There was enacted in 2024 last year. It's a very
Oh yeah, 2024. Yes, thank you, George. And so here's a snapshot. The next slide, please. So I wanted to give you a snapshot of what the legal and policy concerns are. The law requires expensive EPA-approved monitoring methods to allege any violations. It has some confusing, very confusing restrictions on data collection and analysis, requiring a QA certification, and also use of state-approved laboratories for analysis. It has a data communication provision, which really constrains in ways that are hard to understand how communities can talk about their air data. And finally, it has some draconian fines for violations, $32,000 per day for violations with an additional $1 million for intentional violations. Next slide. The Environmental Integrity Project and Public Citizen filed a lawsuit in May 2025, a year, as George pointed out, a year after the law was enacted. The suit argues that the law infringes on free speech and the right to petition the government, and it creates a chilling effect on the ability of individuals and community groups to collect and share data. The lawsuit requests that the court declare the law unconstitutional and stop Louisiana officials from enforcing the act. Next slide, please. I just wanted to touch on the plaintiffs. The lawsuit was brought on behalf of 6 community groups, and I list them here. And it's just really encouraging to see grassroots organizations organizing around pollution in their communities. You can see the name of the lawsuit: Rise St. James versus Burdette, who's the secretary of the Louisiana Department of Environmental Quality. Rise St. James is a faith-based grassroots organization started 6 or 7 years ago on environmental justice concerns. Next slide. The amicus brief that AAPS prepared, you can see our partners there at the bottom. We worked with the American Thoracic Society, a group of 30,000 medical experts. We were helped by the Environmental Law Clinic at Case Western Reserve, and the suit was actually filed by the Gulf Regional Office of Earth Justice. So the brief focuses on the court on understanding what community air monitoring is, how it works. We provide some background. 2, we describe the current U.S. air monitoring system and explained how community air monitoring fills gaps. 3, we clarify some misunderstandings about data quality practices that are used in community air monitoring. 4th, we demonstrate how community air monitoring contributes to enforcement, often as a screening tool, sort of a first set of data that then can be followed up on by the enforcers. And then finally, we express some concerns about negative impacts of the Louisiana law on public health, impacts on air pollution research, and then also how it may set a negative precedent for laws in other states and potentially other kinds of citizen science. You can read the brief. I have a link there and learn a little bit more. The judge will need to decide whether the court accepts the brief. That will happen over the next couple of months. Next slide, please. I wanted to point out a separate brief that was submitted by the Environmental Defense Fund and the Natural Resources Defense Council, same time as ours, on September 5th. They raise and sharpen the legal issues: freedom of speech. Communities should be able to collect, use, and disseminate air information. Second, the right to petition. The First Amendment does not allow states to restrict the right to petition to redress grievances. And in this case, the monitoring data allege violations in Clean Air Acts, in clean air laws. And then the third one is the U.S. Constitution's Supremacy Clause that says that state laws can't conflict with federal laws. The situation here being that the Clean Air Act provisions authorize EPA to bring enforcement actions based on, quote, any information available about potential violations, which then should supersede the Louisiana law. My last slide. AAPS believes that trying to stifle community air monitoring is short-sighted and counterproductive, and I wanted to end on some of our concerns that are a little bit broader with a narrow issue of air monitoring in Louisiana. First, there's a chilling effect on air pollution and health research in Louisiana. The law is silent on what happens when a researcher publishes air monitoring data that might show potential violations. Second, there are clear adverse impacts on public health from air pollution, and by stifling the collection and dissemination of data, it's going to especially hit rural areas, lower income communities, minority populations. Third, it would be unfortunate if camera served as a model for other state laws. I have a hot link here. Kentucky passed a law, not as bad as Louisiana's this year, and proposed legislation draft legislation was proposed this year in West Virginia and Ohio. And then lastly, there's potential concern about future impacts on other participatory science activities like volunteer water monitoring. So with that, I hope I've seeded the conversation, stimulated some questions and discussion, which is our goal today. And back to you, Rihanna and Jennifer.
Thanks so much, Jay. It's Rihanna that's going to facilitate the Q&A. Thanks in advance to everybody who submitted questions as part of registration.
Yeah, and that is exactly where we wanted to start. So I have a couple of questions that came up in the registration that I was going to have Jay and George and Adrian, if you have any thoughts on them, to get us started with. But I also have opened the Q&A tool. And so if you have some questions, if there are things that you would like to hear our presenters talk about in this first round, I think if we're going to focus more on general topics or clarifying questions, either about the amicus brief, about what these laws say, and then we will have a longer period and smaller breakout groups where you can ask more detailed questions, more personal anecdotes and things. And so this Q&A will be recorded. And so if you have a question that requires more context or is a little more nuanced, maybe save those for the breakout discussions. But for now, if you have any big questions, go ahead and put those in the Q&A tool and we'll pull those into the conversation. But I did want to start us out with a question from the registration about what strategies groups can use to protect future projects from being banned under the definition of community monitoring. So it seems like these laws are really focused on air quality monitoring. Is other monitoring also at risk, given the precedent that this is setting?
I'd be happy to start, but Adrian and George, feel free to jump in. I think the answer is yes. And you know, we see the trend of some other states picking up the idea of these kind of laws. I mentioned 3. I suspect, and these are being sponsored by some industry groups in states and perhaps a national industry group. And my concern is that it spills over into some very successful participatory science areas like water quality monitoring, which many states use to identify impaired water bodies, which then the state can either do enforcement or increase permitting kinds of activities. So yes, that is a major concern of ours.
And I would agree with that. Volunteer water quality monitoring has been around for a long time, and it hasn't to date seemed to be the kind of flashpoint that community air monitoring is. But there's no clear reason why that would be. It may be that the issues, especially in Louisiana and a few other states, are primarily air issues that have just been sensitive. But there's nothing inherently different. You know, discovering a illegal discharge or something like that could be done by a community watering groups, a water community.
Yeah, or a fish kill. Take a picture of a fish kill caused by a chemical. You know, there are many ways communities can contribute important data to state agencies.
Yeah. So part of the question, I think, was what can people on the call do or communities do to try to head this off? And I don't think there's a real simple answer to that, other than, you know, try to stay aware of things that are in the works, and you know, just have to be engaged, especially in the legislative process. There were groups in Louisiana who were engaged in the legislative process. All the states that we talked about here are states with very strong, I won't partisan, but I think pro-industry majorities, and they generally found it difficult to influence the process very much. But that's what you can do. There are, of course, in every state there are environmental groups that probably do legislative work on legislative issues regularly and know the legislature. And if you're not already engaged with them, that would be who, you know, I would turn to try to head this off.
So I think the other big issue here is the truth and reality on the ground. Is there pollution? Is there something going on? Because if there is, whatever the monitoring technology is or wherever it comes from doesn't really matter. What matters is that there is levels of pollution that are above the standards. And so from what I've read on it, it's talking about that they cannot make enforcement action based only on low-cost data. They would have to put the federal reference methods there and verify it. So it's, you know, in our reading, it's not a complete banning of it, but it cannot be used on its own. But the bottom line, wherever this is what is going on? What's the truth?
Adrian, I agree to a point, but the concern in the law raised in the lawsuit is the basically prohibition against, with penalties, against sharing data alleging environmental violations. And that's just a very problematic construct for a law because that's in fact what citizens do. We think we may have a problem here. I collected some data. Here it is. It seems like a constitutionally protected right. What the state does with that data is sort of the second step.
Sure. I mean, this is in some way like defamation laws, where if you say something about someone that's not true, then they can sue you for defamation. But if you're saying something that is true, it's not defamation. And perhaps something similar would be applicable here. But I agree that it's troublesome. Places like India have laws now that restrict the use of data, even to the extent that universities doing research down there panicked and made all of their sensors private. China owns all environmental data. The government owns it, whether you collect it or they collect it. And so, it's very much controlled there. But it's something that happens in a country like India.
And to put a sharper point on the problem in Louisiana, there's such limited government monitoring. Many counties or parishes don't have any government monitors. And a lot of the monitoring is for compliance with the criteria air pollutants, particulate matter, ozone, and very few on hazardous air pollutants. So there are some monitoring deserts where the government is not doing monitoring, and we know that in many of those areas there are high levels of pollution. So just when communities start, and communities often don't do this work by themselves, they often work with academic experts and others, like the LEAN group in Louisiana, the Louisiana Environmental Action Network, used an EPA grant to hire ACLIMA to come in and do mobile monitoring of hazardous air pollutants. And they mapped sort of where the levels were, and some of them were quite problematic. I really feel that the law criminalizes that work, which it seems like bad public policy.
Yeah, there was a question about that came through in registration about what role societies, universities, and other institutions can play in supporting community collected data. Given the way the Louisiana law is phrased, like, do you fear that universities and other institutions are going to stay away from that? Is there an increased role because they have more protections for them to step up and do more? How can these larger institutions play a greater role in safeguarding this community collected data?
I think the law is ambiguous at best. It doesn't really define community organizations. There are several places where language is included there. But when a community group works with an academic experts and others, my read of the law is that that whole entity is covered by this law. It's interesting that industry groups are not covered when they do their monitoring, even if they don't use EPA approved methods. So yes, I think researchers in the state should be concerned, and medical researchers, air pollution researchers, etc.
I think one thing, it is important to remember that the key trigger, although the law does get broader, it has some other problematic things, but the key trigger is use of data for alleging a violation. So in theory, a pure research data gathering effort that has no intention of making allegations of a violation. And I guess I'm just saying this to kind of reassure the university researchers who might be involved that should be less risky, but the law doesn't define what alleging means. If you put out data that shows certain numbers and you don't say it's a violation, but it looks like a violation, someone may say that you alleged a violation. Anyway, we already know from talking to researchers that they are chilled by this. They worry about it. So I think as the lawyer, I would say you shouldn't have to be worried about it. You can try to stay within that line. But in practice, it's hard not to be chilled because, as Jay said, the law is not that precise.
And George,
Um,
I think I feel more strongly than you do about that. To me, that word allege, if a researcher shares or publishes data, that's anybody can compare what the standard is
Yeah,
for
no,
environmental reg
that's
and look at the
right.
data. You've kind of alleged it, or if a community group uses that data to then allege, to me, it's a very problematic law. Rhianna, I see the question about hazardous air pollutants.
yeah, there's that in the chat. We also have some questions about from Liz in the Q&A tool. One about resources where folks can find out about laws and proposed bills related to community collected data. I think George touched on that a bit, but if you want to, if there's more to say on that.
I think we need to re-energize. We used to have a law and policy working group that George co-chaired with Leah Shanley. And I think we need to reinstate that because I think we're starting to see some creep of laws at the federal, state, local level that we should be monitoring. George, I don't know if you want to add anything.
No, I don't know offhand of a good single resource on this. So that's a good suggestion.
Liz had another question about additional considerations for projects that were funded through the EPA or air monitoring loan programs alongside with commitments to share that data, the tension between the federal funds and promises and the state level restrictions.
Yeah, George and I, through the Environmental Protection Network, are creating technical support for I think there are 130 projects that EPA funded in 2022. About $50 million was distributed to 130 grants, totaling about $500,000 per grant over 3 years. About half of them went to states and half went to community groups. There are 6 or 7 in Louisiana. Those groups are going to be finishing. They now have purchased their sensors. They're up and running. They were not terminated by the Trump administration like many of the other grants related to environmental justice, climate change, and others at EPA. So those projects will be finishing up in the next year or two, and that data will be available. And we're all going to struggle to sort of figure out how to interpret it. I don't think EPA is likely to be very supportive of publishing the results of those projects, and that's why this Environmental Protection Network project that George and I are working on is so important. We want those projects to succeed and for the community lessons to be shared more broadly, not just with the communities that are doing their own projects, more broadly across the U.S.
And I would just add, I think the question was getting at the tension between some of what's built into the work plan for these grants, which includes public communication and use of the data. You know, that's a valid concern. One of the claims being made in the lawsuit is that the state law essentially conflicts with federal law, and part of that is that the federal government has funded groups to do this kind of work, and that communicating the data is inherent to that work. So they're trying to make a legal argument that there's a direct conflict, and the federal law should trump state law. So that conflict is definitely there.
Great, and we did have one more question in the Q&A tool about the potential timeline for the rise of the St. James court case.
Not known. As I understand it, George is the attorney, but as I understand it, the EDF and NRDC proposed a motion to dismiss where the judge could just make a decision that this is clear on the evidence, we don't need a trial. And so that could happen in months. The second option is the judge looks at our amicus briefs, decides whether to accept them, and then lays out a timeline for the court. which can be slow.
Great.
Yeah, I would say, and I don't want to be overly optimistic. I personally, this is just, opinion. I think there's a pretty strong First Amendment case here for at least part of the law. And I could see the court just ruling fairly quickly, at least to strike down some sections and maybe others just that because they're vague and have a chilling effect. So that could make it a fairly short process, but that's probably over optimistic. Courts rarely do things that quickly.
So I'm going to chime in here and thank you for both those questions that have come in from various sources and the responses to them. We're going to go into breakout rooms in about 5 minutes, but before we do so, I'm going to turn to Adrian from PurpleAir just to provide some reflections and synthesis from his expert perspective on this conversation, situation, and moment here. Adrian?
Thank you, Jennifer. Since the very beginning with PurpleAir, I mean, I started the company here in Salt Lake City where we have typical air pollution problems, particularly in the winter with inversions and stuff like that. And, it was something that I did not want to sensationalize the data. I wanted to make sure that the data that we were putting out there was of quality, that it meant something, that it wasn't just calling something out that wasn't true. And I think it's really critical in all of this. If you're going to take a bad sensor that's producing bad data and you're going to represent that in a certain way, then there's going to be a problem. If you're taking data like we did in the beginning, I mean, I put it out there. I said, what does this mean? I said to the community, I'm not making any representations on the data. What do you make of it? And a whole lot of research was done by a lot of different organizations, from air quality districts through to researchers and private individuals. And they came up with the results of what the data means in their studies. And that's important. Like I said earlier, is there something going on? Or is it just sensationalism and untruths? That matters. That really does matter. And PurpleAir really cares about that. We don't want to be representing something that is not, true. And that's why even with our VOC data on the map, you'll see that we talk about it as experimental. We don't know what the relevance is of that data. South Coast has done some analysis on it, and they say it's good at detecting short spikes in VOCs, but not long-term background levels. Things like that. So it's important that the community take the results, study them, look at them, and evaluate them. And based on that evaluation is what you can do with it after that.
Adrian, thank you so much for those perspectives. That's one of the things I know at AAPS that we really stand for, and I'm glad that you called that out, is both the strength of the data as well as the relevance and insights and knowledge of communities. So it's really important to see and hear more from PurpleAir as a connection point.
And Jennifer,
Facilitating that.
if I could just add just a quick grace note to Adrian's point, and I think community groups are learning over the last 5 or 10 years the data quality practices. Like EPA recommends taking a PurpleAir sensor, co-locating it with a reference monitor, and calibrating next to a reference monitor before you put it out in the community. So there are sort of many ways to get to that good science goal that you aspire to.